A Supreme Court analysis of the tragic case of Satvir Singh and others versus the state of Punjab. Tejinder Pal Kaur, the daughter of Narendra Singh, held a BA degree as well as a B.Ed degree before her marriage. On 15 November 1992, she married Satvir Singh, a businessman, and began living in his house. Devinder Singh, the father-in-law, and Paramjeet Kaur, the mother-in-law, also lived in the same house. Though dowry was given at the time of marriage, after 4 to 5 months, the in-laws started harassing her for not providing a car and a house as part of the dowry. They also taunted her, saying she had brought rags instead of wedding costumes. In November 1995, her father Narendra Singh gave 20,000 rupees to Satvir Singh in hopes of stopping the harassment. However, the abuse continued and the money only provided temporary relief. On the night of 16 June 1996, Satvir Singh became furious after tasting overly salted salad, allegedly tampered with by his mother. He verbally abused Tejinder, and his parents joined in, escalating the harassment. They suggested she kill herself by jumping in front of a train. On 17 June 1996 at 4 a.m., Tejinder left home alone and went to the railway tracks and started walking on a railway track. Within 15 minutes, a Jalandhar-bound train arrived and she was run over.
She survived but was severely maimed for life.
The Sessions Court convicted Satvir, Devendra and Paramjeet under Section 306 and Section 498A. They were sentenced to 2.5 years of rigorous imprisonment and Rs 10,000 fine under Section 306 and 2 years imprisonment and Rs 5,000 fine under Section 498A. The convicted appealed to the High Court against their conviction. The victim Tejinder appealed to the High Court for enhancement of the sentence. The High Court replaced the conviction under Section 306 with the one under Section 304B read along with Section 116 for abetment of dowry death. The punishment was also enhanced from 2.5 to 5 years rigorous imprisonment. Satvir Singh appealed to the Supreme Court.
The Supreme Court held that Section 306 applies only if suicide happens due to abetment. There is no offence if suicide was merely attempted but not completed. The Apex Court further held that there can be no conviction under Section 511 as the accused's act of abetting suicide is already punishable under Section 498A, so the general attempt law of Section 511 does not apply.
The appellants contended that Section 304B does not apply to suicide cases, even if linked to dowry harassment, and that abetment under Section 304B cannot apply if the woman's death does not occur within the statutory period of 7 years of marriage.
The Supreme Court rejected the appellant's argument and held that the essential components of Section 304B IPC are that death of a woman within 7 years of marriage under unnatural circumstances, and that she must have been subjected to cruelty or harassment for dowry soon before her death. The court clarified that suicide is included under Section 304B if it results from dowry-related cruelty. Section 306 read, with Section 113 of the Indian Evidence Act, applies to suicides due to cruelty, but Section 304B is a stricter, more serious offence with harsher punishment. The Supreme Court held that harassment is alleged to have happened 4 to 5 months after the marriage. No further proof was provided. The next demand is alleged to have happened only in November 1995 and Rs 20,000 was alleged to have been paid for an unverified purpose. The time gap of 3 years between the demand in 1993 and the suicide in 1996 fails the soon before death test as mandated under Section 304B. There is insufficient evidence for any dowry link to the suicide attempt. The Supreme Court held that there can be no conviction under Section 116 IPC linked with Section 304B or 306 IPC. There is insufficient proof of dowry-related harassment soon before the incident. However, the Supreme Court upheld the conviction under Section 498A IPC as the evidence supports general harassment though not necessarily dowry-linked. Finally, the Supreme Court reduced the imprisonment to the time already served as appellants had already spent a substantial time in jail. However, the fine was increased to 1 lakh rupees each and total of 3 lakhs rupees to be paid as compensation to the victim. In case of default to pay, a penalty of 9 months more imprisonment if unpaid within 3 months. As a special consideration, The Supreme Court granted leniency as the aged appellants Devendra Singh and Paramjeet Kaur were granted leniency as they were both over 70 years old.
The Supreme Court emphasized that the concept of soon before death is critical for the application of Section 304B of the IPC. Moreover, any payments made after marriage do not automatically qualify as dowry without proof of their linkage to marriage demands. Prosecution must strictly prove dowry harassment, as any gaps in evidence weaken the case. The courts must avoid presumptions unless backed by clear testimony. Thanks for watching.